I'm gonna need some. One, two,
His offer was 18, I made it 16.
3, 4. Yeah, he's got 1, 2, 3, 4, 5, 6, 7, 8, 9 prior.
Drug cases, yeah.
Not all drugs.
Most of them.
Are drug cases. 9 prior felonies. No, I'm not going to accept a state jail felony plea agreement on these cases. That doesn't make any sense unless there's something wrong or there's some issues that I need to know about. But I think it's time for it's a 3rd degree punishment range. Yeah. I mean, we just had one from 2024. What was the outcome on that one? Do you know?
I don't remember what happened in 24 cases.
Oh, this is Mr. Hoffpowers?
Yes.
I'll look.
Okay.
I'll look and see if there's a reason, Judge.
Yeah, I mean, it's a burglary of a building, it's an evading with previous convictions. I understand those are state jail felonies, but they're his 10th and 11th state jail felonies, so I'm not going to accept this plea agreement. I'm deleting the paperwork. You can go back with the bailiff, and then I will, if you want to look at it now, you can, or you want me to
I'll take
reset?
time this morning.
Okay, thanks. And I'm deleting that paperwork.
Okay.
Good morning, are you Kaylin Welcome? And Mr. Parker, will your client waive the formal reading of the indictment?
Do well, Your Honor.
Mr. Welcome, in cause number 25, DCCR 1156, you're charged with a 2nd-degree felony offense of aggravated assault with a deadly weapon from July 9th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Welcome is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with that agreement to a term of 7 years in the Institutional Division of the Texas Department of Corrections. There is a finding of a deadly weapon in that case. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I need that. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker, okay? Good luck to you, sir. You can go back with the bailiff. So, again, you are Jarrett Matthews, and Mr. Matthews, get back to my, get back where I need to be here, hold on. Cause number 23, DCCR 1211, and Mr. Matthews is charged with unlawful possession of a firearm by a felon from September 13th of 2022. Mr. Kimler has filed a motion asking that I reduce his bond, and bond is currently set at $30,000. It looks like, is that correct,
Is that right?
Mr. Kimler?
I think it was one. I thought it was it's 100 is what I thought.
So it was initially set at 30. So let me see here.
100.
Okay. So I wonder why,
We'll take 30, Your Honor.
sure you will. I'm just looking at, okay, so apparently back in September of 2022, there was a bond set, and then I guess Mr. Matthews made that bond,
Then he went into custody in Louisiana and stayed in custody.
and when he got back, it was reevaluated in a bond set at 100,000. So I have and will take judicial notice of the court's file, including the probable cause affidavit, the magistration documentation that was used at the jail, and also the public safety report. Mr. Kimler, you may proceed.
Your Honor, I suppose the initial bond was 30,000, and then, of course, he accrued the cases in Louisiana, was in custody on the next court date, so was unable to make that. I don't think there's been any type of intervening circumstances from the time that he got the $30,000 bond and now that would warrant an increase in the bond other than just being out of state incarcerated.
Well, that we didn't have the public safety report system back in 2022, so I'm sure the new magistration process, that magistrate looked at the several pages that are included in that.
I'll just let Mr. Matthews address the within Your Honor. He can explain his current
Raise your right hand the best you can, please, sir. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, go ahead.
Explain to the court what your current situation is as far as your living arrangements, where you would be residing, and what your plans are.
I still stay in Lake Charles with my mom. From when I bonded out here the first time, I never missed court. I never failed a drug test or any of that.
But you were in custody in Louisiana for something between then and now?
I caught a charge prior to the charge I caught out here.
Okay.
This was my most previous charge.
Most recent.
Most recent charge.
And what was that charge?
It was a convicted felon with a firearm charge.
Jefferson Davis Parish, right?
Yes.
And what was your sentence?
4 years.
Okay.
I was in the military 7 years. I have a little PTSD.
This part is where Judge West goes full mentor mode. She's not just a judge, she's practically giving life advice from the bench. When she says, "Quit acting like you're acting in jail," that's not anger, it's frustration mixed with hope. She's reminding the defendant, you're one step away from a break, but your behavior could blow it. Judges don't hand out second chances easily, so moments like this really matter.
I was going to dental appointments before I got incarcerated.
All right. Anything else?
It's a 4-year offer, Your Honor. He's wanting to try to get probation, so I would like to try to get him out, maybe to get established a little bit to show that if he come back on a contested sentencing, that he could do the probation. Is that what you believe?
Yes, sir.
Did we have a hold on him when he was in?
It's my understanding, Judge, and the reason for the offer being that obviously you see the offense date is quite
Right.
old. He should have had a hold at some point in time. I obviously appreciate his military service and will be willing to work with him on that. My problem being is that he's not a resident of this county.
Right.
Well, for
So
Veterans Court, right? But I
Right.
think we could transfer the probation.
well, I guess if he wants a probation, that's one thing, and that's up to them to offer that. If he has been incarcerated for most of this time, then we can make that, even if we didn't have a hold, I can make a finding that we should have, and if you get that documentation on how long he was in custody there between the time of the indictment, nothing before the indictment,
Right.
but the time of this indictment and now. Okay, so obviously it would need to go back if he was in custody, but I would need documentation of that. And so I don't know if that's something you guys want to take into consideration.
And that's what my notes have reflected, the credit for the time that I was anticipating we would have had a hold, because he's been in custody at least 18 months now.
Right, which, it's,
He's asking
he would have enough time under his belt. And I understand what he's asking, but I don't know if y'all want to visit about that.
I've explained.
Opportunity?
He wants an opportunity to do probation, so.
Well, that's between y'all then, and so
Well, it
then,
could be a-
all right, back to the
it
bond,
could be a
so,
gap, all right.
look at one more thing real quick. I mean, I'm not, so here's the thing, he's obviously a convicted felon, picked up an unlawful possession of a felon over in Jeff Parish, picked up another one after that over here. So at this time, based on all of the information that I've received, again, from that public safety report as well as the criminal history, the facts of the case, I'm going to deny the motion to reduce the bond. You guys can visit about any options, and then we'll get it set for an announcement.
Yes, sir. I'll
right.
try to maybe figure something out.
All right, thanks. Just to be sure, you're Jacoby Frazier?
Yes, ma'am.
And so, Mr. Frazier, I'm going to reset your sentencing, and I'm going to have a doctor come out and visit with you. They might do it online on that phone system, or they might come out. You need to cooperate with that. I just want to make sure what all is going on with you and what we need to go forward if I'm going to accept this plea of a probation. It's also very important that you quit acting like you're acting in jail. Do you know what I'm talking about?
Yes, ma'am.
You do, don't you?
Yes, ma'am.
All the things you've been doing, I have pages and pages of incident reports on how you're behaving in our jail. And I understand that you might have some issues with some behavior stuff and some things that we're going to hopefully get taken care of when you get out, if you get out. But you have got to quit treating the correctional officers disrespectfully. You've got to quit calling names. You quit talking like you're talking out there. Because if you don't, I don't have to accept this plea agreement and give you a probation. Do you understand?
Yes, ma'am.
So just lay low, do whatever time you got to do out there until we get you back. Talk to the doctor.
Did you catch that? The defendant just mentioned he served in the military and has PTSD. This is a subtle but crucial moment. In Texas, judges often weigh mitigating factors like service-related trauma when deciding bond reductions or probation. But watch the judge here. She's firm but fair, trying to balance empathy with accountability. It's a masterclass in courtroom nuance.
Doctor, and then we'll see where we are when you get back. All right? Go back with the bailiff. Good morning. You're Ronald Spites, and Mr. Spites is charged with the offense of manslaughter and cause number 25 DCCR 0920. And what is the announcement?
Judge, we're asking the court for maybe a regular reset so we can continue reviewing the discovery. Mr. Smith and I are also talking about options for a resolution. But
You were just, yeah, this is real new. Any issues? All right, we'll just do a normal reset, Mr. Spites, and Mr. Gertz will be able to get more information, go over that with you, and we'll see where we get at the next court date. Thank you. Good morning. You're Deandre Willis. Excuse me. This is 25 DCCR 1048. And Mr. Willis, you're charged with the offense of burglary of a habitation, a second-degree felony from June 26th of 2025. And what is the announcement?
Your Honor, the complainant is Mr. Willis's girlfriend. I believe she signed a non-prosecution affidavit.
Okay, Ms.
She
Martina.
did, Judge. The offense involves a firearm that was stolen, which is what gives me some concern. I do have the non-prosecution affidavit. I'm not inclined to honor it without her presence here in court, which we have requested, but she's obviously not here unless we'd like to do a bailiff's call
If you'll,
outside.
yeah, we can call her name at
Colette
least.
Richards.
Colette Richards, please.
In the alternative, Your Honor, if I may just have a week or two to issue her a subpoena, if she wants to proceed with the dismissal in this case, I'd like her to explain to the court why, Dr. Programmer. Or even next Monday, if you'd allow.
Well, or Tuesday. We can do Tuesday. I just want to make sure that is that enough time for you? Okay, because I know after that,
I'll send it out.
after that we're down
I'll send it out right after Dr.
for a week. All right, thank you. So what I'll do is I'm going to reset it just 1 week for the state to reach out, send a subpoena if they can, and get her here, and then we'll go forward next week on Tuesday. You go back with the bailiff. Good morning. Are you Robert Lowe?
Yes, ma'am.
Just a second here. I signed those but didn't fill in the date, if you could for me, please. And Ms. Holmes, will your client waive the formal reading of the indictment in each
He
case?
will, he will, Your Honor. Sorry.
It's been
One of those
it's been a long day already.
And Judge, if we may, we're gonna proceed on 3. I
Yes, ma'am.
collected in the paperwork, subject to the PSI. I know cases are always subject to
Sure.
your discretion after the PSI, just due to the nature of it. That's why I included that.
Yes, ma'am, thank you. All right, Mr. Lowe, in cause number 19-32660, you're charged with the third-degree felony offense of possession of child pornography from June 4th of 2018. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? And then in cause number 19-32661, you're also charged with the third-degree felony offense of possession of child pornography from June 4th of 2018. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? And then finally, in cause number 19-32662, you're also charged with the third-degree felony offense of possession of child pornography from June 4th of 2018. And how do you plead to that charge? And are you pleading guilty freely and voluntarily, and because you did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And it looks like the agreements that you've reached on these 3 cases, that it would be a 7-year deferred probation in each of those cases. There would be a $1,000 fine. You would be required to register as a sex offender, subject to the PSI, it says, and I guess any other conditions that I felt like were necessary to place on you. That as a condition of this agreement, if I follow it, the state would also dismiss cause numbers 19-32663, 32664, and 32665. Is that your understanding?
Yes, ma'am.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Mr. Lowe is not competent?
No, Your Honor.
All right, sir, in each of these cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we will come back at a later date for sentencing. Just based on the nature of the offenses and what the agreement is, I'm not going to do anything to modify the bond at this time. We'll just get that pre-sentence report done, and then we'll see where we are when we come
And
back.
he was at large for almost 5 years, so I think it's probably better.
Okay, sounds good. You can go back with the bailiff.
You can have a question.
Yeah.
How long would I have to register?
That'll be a question between you and your attorney. We'll go over that at sentencing. There's, it might even show on that, on the pad, that probably needs to be signed at this point. I mean, these are registrable offenses, correct?
Yes.
Yeah. Y'all need to go ahead and
Do it
sign
now?
the sex offender
Okay.
registration while you're here today. That makes it easier, and you can go over that with them. So I do want to make sure you understand, as part of all of these agreements and pleas, that you will be required to register as a sex offender. How long and all of that you can go over with Ms. Holmes. Y'all are going to sign another document today that shows that you have gone over that and that you understand you will be required to register as a sex offender. Okay. And lifetime? All right, it's a lifetime registration.
Okay.
All right, thank you. Yeah, and if y'all, and you don't have to come back in front of me, just send it through and I'll send it through. Good morning, you're Travion Thomas. And will your client waive the formal reading of the
He
indictment?
will, Your Honor.
And, okay, Mr. Thomas, let me do this.
It's enhanced to a third.
Gotcha.
State jail enhanced to a third.
Thank you. Mr. Thomas, in cause number 25 DCCR 1151, you're charged with the state jail felony offense of theft of property with previous convictions from June 11th of 2025. The indictment alleges you were previously convicted of theft July 17th of 2023 and then again April 10th of 2025. It further alleges that you were convicted of possession of a controlled substance, a state jail felony, April 25th of 2013, and after that was final, you were convicted of forgery of a financial instrument, a state jail felony, September 11th of 2015. And how do you plead to that charge? And are those prior convictions all true? Did you enter your plea of guilty and true freely and voluntarily? And because you've actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, Mr. Thomas, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find those 2 prior convictions true. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Yes, we put a notation, that the state will not pursue. There's possibly an additional charge, from that night. It was a
Yes.
prohibited item in a.
Yes, I saw that, and that's part of that agreement, correct, Mr. Coleman?
Yes, Judge, the unfiled possession of a prohibited item in a correctional facility.
Okay, thank you, Mr. Coleman. All right, you can go back with the bailiff. Good morning, sir. Are you Hakeem Thomas?
Yes, ma'am.
And Mr. Thomas is charged in cause number 25 DCCR 0843 with the first-degree felony offense of aggravated robbery. And Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at,
$600,000.
okay. And Ms. Malfino, you have a witness. Do you want Ms. Malfino to go first? Would you rather go first, or?
No, I prefer she can go.
Go ahead, Ms. Malfino.
Okay, Judge, just for purposes of the record, I would tender to the court, just for ease of use, states exhibit number 1, which is a probable cause affidavit in this case, and I will call protection handling.
Any it's in my file. Do you any
Right.
objection
No
to,
objection.
states 1 is admitted for purposes of this hearing. Good morning, sir. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. Go ahead.
Could you please state your name for the record?
Dwight D.
And how are you employed?
Beaumont Police,
How long have you been in the city of Beaumont?
31 years.
You're a certified peace officer in the state of Texas.
Yes, ma'am.
And you and I discussed this case involving Hakeem Thomas as well as his co-defendant Tyree Hartley last week. And we're here in order to address the bond in this case. Can you briefly go over your involvement in the case and your familiarity with the facts in this case and why you think it's important that this defendant remains in custody?
My involvement is through Southeast Texas. I love that task force. We deal with auto burglaries, and our new offense, as was added to a penal code called jugging. We believe that this offense started out as a possible jugging on breaking into a car, which ended up into injury with two of the guys involved. One standing here as well. That ended up injuring an infant child through coordinated efforts of us locally here in Beaumont, myself, officers on the street, along with deputies of the Chambers County Sheriff's Department. We're all involved to have these guys arrested.
So they did actually flee from this jurisdiction into Chambers County after this offense, which again involved an infant child in the back seat of that car being injured when they attempted to break into that car and retrieve the money that the child's mother had retrieved.
This part is where Judge West goes full mentor mode. She's not just a judge. She's practically giving life advice from the bench. When she says, "Quit acting like you're acting in jail," that's not anger, it's frustration mixed with hope. She's reminding the defendant, you're one step away from a break, but your behavior could blow it. Judges don't hand out second chances easily, so moments like this really matter.
Obtained from the ATM.
That's correct. The ATM of the bank, that vehicle, the dad left the vehicle, and the mother and infant child were in the back seat of the car. Not only did they break into the car with shattering glass on top of the baby and the mother in the car, with her continued efforts during the crime itself, they didn't stop. They kept on. Once they were successful, if you could say that, in any kind of theft, they did flee from here and were actually located, found in the same vehicle.
And did you subsequently with Detective Andrew learn that both of these defendants in this case had committed similar types of acts in various jurisdictions across Southeast Texas, Harris County, Fort Bend County, Austin, etc.?
Yes, ma'am. Some of it did happen that actual day, and of course some of it was put together, shredding the background of those who remember.
And is it your position, based on all of your years of training and experience as an officer here in Jefferson County, Texas, that to maintain the security and well-being of the safety of the citizens of Jefferson County, that it be best that pending prosecution of this offense, this defendant at least remain with some kind of a high bond from this court?
Yes, ma'am.
Yeah, that's what it should.
Thank you, Mr. Lewis.
Yes, just briefly. Now, you said you were definitely part of the investigation of this allegation, correct?
That's correct.
Now, during your investigation, was it ever shown that a weapon or any other weapon was exhibited to the plaintiff witness? Or so there was no weapon involved as far as we know?
Not that I'm aware of.
Okay. And as far as your investigation as it relates to my client, was it any statements or evidence that showed that he was involved with the actual breaking of that weapon, of the glass, or possibly injuring the child involved?
Not that I'm aware of.
Is there any evidence that would show that they even knew it was an infant child in the car at the time?
No.
Pass the witness charge.
I've done it for just
Thank you. Thank you, Officer Dean. Any witnesses? Would you wish to call your
No.
client with regard to his financial status? Mr. Thomas, come back around. Best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, go ahead.
Mr. Thomas, as far as your financial situation, you're currently in custody, correct?
Yes, I see.
Now, Do you have any money saved up that could be used for your bond?
No, sir.
Do you have any property that could be sold or vehicles or anything of that nature that could be sold in order for your family to come up with your bond?
No, sir.
Who would be responsible in trying to come up with the bond amount for you?
My mother and my wife.
Your mother and your wife? Have they been in touch with any bondsmen,
Yes,
currently? Okay. And from the information you received, how much of a bond or commitment they will be able to make to try to bond you out?
Complete bond amount, between $70,000 and $100,000.
Between $70,000 and $100,000. Okay. Now, were you employed before you came to custody?
No, sir.
Do you have any employment or anything available to you if you're able to make bond?
Yes, sir.
And what would that be?
Being a helper to my wife's father, his CDL trip.
Okay. And that will give you enough money to be able to take care of any pretrial conditions or anything you need to do with
Yes,
your representation at this stage?
Yes, sir.
Okay. I pass the witness info.
Ms. Malfino?
Mr. Thomas, tell the judge a little bit about your criminal history, starting when you were a juvenile.
I have no juvenile record.
Were you in trouble as a juvenile over in Harris County?
No.
What about your theft, your state jail felony theft from a person, which is basically another way of saying,
That's
who
not
did you
juvenile,
rob?
no.
Don't talk over her, okay? Just wait till
Yes,
she's finished talking so the court reporter can take one at a time.
ma'am.
Where was that?
Go ahead, Ms. Malfino, you might want to read.
Your theft from a person, which is basically a robbery, where was that?
2021,
Where? In Harris County?
Rosenberg.
Have you been in trouble in San Antonio?
No, ma'am.
Have you been in trouble in Austin?
I have a pending case in Austin right now
For what?
for a robbery.
Do you have any kids?
Yes, ma'am.
Someone would have done this to your wife and your baby would have been in the car. What do you think that person should get? Prison time?
I don't understand this.
I don't know.
All right, anything else?
Nothing else for this witness, Judge.
All right, you may make argument.
Judge, as far as this case goes, you've seen it is charged as aggravated robbery, but it's one where we don't have a deadly weapon involved or anything like that. The biggest issue, I think, with this situation, of course, is my client does have some criminal history and lives out of county. I believe there's already some bond conditions in place for him to have the GPS monitored and be able to go to be in Harris County, come back and forth for court and everything. We are asking for a bond in between $75,000 and $100,000. I think that, including with the GPS monitoring and everything, would be enough to cover, one, secure his return to court, and also, of course, satisfy any public safety concerns while these cases are pending. He does not have a hold from the case in Austin, because I believe he's still on bond for that situation.
I found it out when I'm in custody.
Right. So he is on bond for that, so he will be allowed to be released. My understanding, there's not been a court date set up there. We don't anticipate that interfering with us here as far as any type of issues. And from
When did you make bond on that case?
July, sometime in July.
Okay,
I'm not sure the exact date.
okay, that's
sometime
fine.
in July.
All right, go ahead.
But from talking with his family, they have been involved with this case he has going on up in Austin, and that I think that actually will be resolved pretty quickly, and won't interfere with what we have going on here.
What, if anything, and Officer Dean may know about, I know you noted some other counties where there were some potential cases or issues. Do you have any other information on those?
I have reached out to Fort Bend, Judge. I have had difficulty in getting a final answer. A charge looks very looming. How they initially filed them, I think one of the impediments that I'm up against is in Harris County, Fort Bend County, that surrounding area. They have dropped a lot of stuff down to some very low amounts of time. So it looks like if an initial charge comes in as an aggravated robbery, it ends up 6 months later as theft from a person in the state jail. So that's really the totality that I've been able to.
Do you have any other
obtain
additional
from the
information?
co-defendant.
No, ma'am, that's exactly what I was gonna say. It looks like there's been some initial charges that were actual aggravated charges that were wrong now.
Okay.
And I would also ask if you take judicial notice of his incident behavior report.
I will. I also have, and I think you guys should have received 7 pages of incident reports from the jail as well, which obviously y'all know my thoughts on that. And so, anything else?
No, Judge, and the state does not object relief necessarily in this case, just not, I would ask that it remain in an amount at least about $350,000.
And Judge, if I may, to the jail incident reports, I think those were like early on when he got into custody. Of course, Mr. Thomas did speak about those and how, of course, he should conduct himself out there, and I don't think that he has had any other issues since that conversation.
I guess my concern, and I understand from the probable cause that the allegation is that Mr. Thomas was the driver of the car, but I don't know that that makes it any better whatsoever, because it doesn't sound like there's any evidence on why he and Mr. Hartley were in Jefferson County, if they're from Harris County and that's where he's going to live, why they're in Austin, why they're wherever they are, other than to come into our county and break into people's cars or jug, which has become a huge issue. And so based on the evidence today with regard to this specific offense, based on the jail incident reports, based on the information received through, again, take judicial notice of the court's file, the magistration information as well, the fact that there is at least one pending case that is similar, others that sound similar, just with some different outcomes, I don't think it is in anyone's best interest that Mr. Thomas have any relief today, and so I'm going to deny the motion to reduce the bond. We will reset the case and for an announcement and see where we get. All right, thank you, sir, for being here, Mr. Kane, Officer Kane. All right, do I have a?
He's decided to go with the cap.
All right, sir. Again, you're Jarrett Matthews, and will your client waive the formal reading of the indictment?
So
Mr. Matthews, in cause number 23, DCCR 1211, you're charged with a third-degree felony offense of unlawful possession of a firearm by a felon from September 13th of 2022, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 4 years in prison, which means you're leaving your punishment up to me. As long as I give you 4 years or less, then you cannot appeal that decision. Do you understand? You have an absolute right to have a jury come in and determine 2 things. One, if you're guilty or not, and then you could leave your punishment up to them if they find you guilty. If we go forward this way, you're waiving that right, and is that what you want to do? State tenders number 1.
Okay.
It's admitted. Is there any evidence that Mr. Matthews is not competent?
None that word.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report that will give me more information about you and your case, and then we'll come back later for sentencing. All right, you can go back with the bailiff.
And here's where the case takes a dark turn. An infant injured during a botched robbery attempt. The officer's calm, detailed testimony paints the scene vividly. This isn't just theft. It's violent and reckless, and it's why the prosecution pushes for a high bond. But keep listening, the defense is about to fight back hard, arguing there was no weapon, no intent to harm. This clash sets up one of the most dramatic moments of the hearing.